Savvy Business Radio, home to over 500,000 listeners per month, and runs in syndication on 8 AM/FM stations nationwide, including iHeartRadio and 6 podcasting platforms. To find out about our paid sponsorship opportunities or to become a guest and find out how we can help you get your message out in a bigger way, call 732-474-7375 or email Christina at savvybusinessradio.com.
Welcome to Savvy Business Radio. This is your host, Christina Nichman. Each week on Savvy, we support individuals and successful individuals in sharing their expertise, knowledge, tips, and stories with the world. Our guest today is Craige Thompson, patent attorney, also known by his clients as the Examiner Whisperer and the best-selling author, Patent Offense: 7 Steps to a Safe, Secure Patent Portfolio. Craige will share with us everything you have to know to get your patent approved. Find out more and get your patent started today at thompsonpatentlaw.com. Hi, Craige. Welcome to Savvy Business Radio. How are you this evening?
Well, thank you, Christina. It's a pleasure to speak with you today.
I think I told you before our interview that we've never talked on this topic of patents. You're a patent attorney. Today we're going to discuss why do people need a patent? What is it for? Why do you need a patent attorney? Why can't you do it yourself? Some of these very important questions that will help businesses out there who are thinking about getting a patent, and you're going to be their go-to guy today. So before we go there, just share a little bit with our audience what brought you to becoming a patent attorney and starting your firm.
Well, I was an electrical engineer for 10 years and designing all sorts of products. And I was never an inventor type myself, but I really can understand technology. So it was a really natural fit. I always had an interest in doing something a little bit more business-like. And so it was kind of a natural fit when I went into law school after, the 10 years of engineering, and I knew exactly what I want to do, be a patent attorney and someday start my own practice.
Yeah.
Actually, I started out in my law career at the #1 patent litigation firm in the country, Fish and Richardson. So it was really, it was a tough getting up to speed, but I was working with some incredible people that I highly respect there. So I got some great training. So that's kind of my path.
Yeah. And I'm sure we're working with a lot of clients and business owners. What have you seen as some of the major myths or mistakes regarding patents with business owners and inventors?
Well, the most common mistake that I've seen is something that, and I have a bit of a sort of a contrarian view on a lot of things with patents. So this is not in the mainstream, but I think most people don't start a patent the right way. And by that, I mean, Christina, that the thing that they're missing, I boil it down into one thing, it's they don't start with what I call a point of novelty that they can articulate in one sentence. And that is the mistake that makes a lot of patents not achieve the monetization potential that they could. And so it's really a shame. And so it's kind of my crusade, if you will, and I wrote a book about this whole process that I created around this to help business owners and businesses to get this one thing right. Because if you miss this, your patent process might not achieve what you want it to achieve and might be very expensive and a waste of time.
Yeah, absolutely. And your book is called The Patent Offense Book: 7 Steps to Safe, Secure Patent Portfolio. Yeah, and very important, because I think sometimes we think that, hey, why get a lawyer? I could do this myself. How hard could it be? And I don't know about many people out there, but I did my school loans and such to the government. That was not easy. So imagine a patent. I can only imagine.
I've had a lot of clients come to me with horror stories where they went the kind of the LegalZoom route where they advertise patents for $199, or they get with some invention submission corporation. And they have a lot of bad experiences where they spend a lot of money and get nothing for it. The other thing, and so they're telling me, I'm not telling them they shouldn't do it. I know it's a bad idea. I don't land my own plane. I don't do surgery on my own kids. I mean, it's very complicated. Patent law is very complicated. There's three disciplines you really need to have a handle on to be really good at writing patent applications. And engineers have one of them. They understand the technology. That's great. Inventors, they understand the technology better than anyone, of course. But what they don't necessarily have a handle on is no one has. It's very complicated. It like an apprenticeship to learn this stuff. For years it takes to understand the patent laws. They're complicated. They change all the time. They're very subtle. They're based on court cases. It's not intuitive. So that's a big trap. And the third thing is, to write a good patent, you really have to understand business goals, but not understanding the patent process and the patent laws. And the patent office is a big bureaucratic, it's like your student loan example, Christina, there's a maze of procedures that we battle every day. And if you don't know what you're doing, you're going to get chewed up. As a matter of fact, the patent office even has a form paragraph they send out to people, and then they'll say, it looks like you're trying to do this yourself. We really, really encourage you to get a patent attorney. So they actually have a template paragraph that, that kind of says it all right there.
Yeah, absolutely. And what you just mentioned before, point of novelty, I would venture to say this is a very important thing to do for your business. Say you're just starting a business out and you've got this fabulous idea that you want to patent or invention, get right out of the gate. It's important actually to have that one sentence to really describe and have that point of interest or a point of differentiation from other businesses before you even get out of the gate.
Well, it's the point of novelty that I'm talking. I agree. The point of novelty that I'm talking about is something that's very specific. If you can kind of define it this way, a point of novelty is something that if you don't have it, you're never going to get a patent. No claim gets through the patent office without having a point of novelty. None, zero. So we kind of reverse engineered the patent process. And when I kind of stepped back and looked at it, I took my engineering background and systems kind of mindset, and I looked at it, I reverse engineered, after doing over 1,000 patents and working with people, inventors in 5 continents and all over the place, almost all 50 states for 15 years, I've seen enough of this where we said, let's begin with the end in mind. What's the one thing that stops people from getting a patent or even a good quality patent? It's the point of novelty. Instead of going through the patent office process and finding out you don't have a patent and a point of novelty, or you do have a point of novelty, let's figure that out before you spend all the money and 2 or 3 years of time and $20,000 or $30,000 to figure out that you don't have a point of novelty. Let's figure that out up front. And that's something that our clients really appreciate. Before starting any patent, that's the right way to start any patent in my view.
Yeah. So would a point of novelty also differentiate you and keep your patent from being, because I'm guessing one of the things that stops people from getting a patent is that it could be something that could be easily used or picked up by other businesses and kind of translated ever so slightly different and used.
You put your finger right on the button here, because the point of novelty is the key to a successful patent that makes you money and gets a really high ROI. By the way, I believe that if a client can't convince me that they have a business case, a most likely business case, that their patent, if we get a patent for them, they're going to get at least 100 times ROI on their patent, then we tell them it's not worth getting a patent. They need to be getting at least $2 to $3 million. A patent is really about business, and you mentioned competition and designing around your patent. That's people are afraid of that, and rightfully so. And that's why identifying a strong point of novelty up front is so important. And that's a unique thing that we do, that I'm told by a Fortune 75 in-house counsel patent attorney that works with lots and lots of firms. He says nobody else is doing anything like this. So it's been working tremendously well. As a matter of fact, the results are, we look back and kind of audited what's actually the performance of this process. We're getting patents through the patent office. They typically take about, I think, 30 months, but we're doing 8 months faster than the national average.
Wow.
Because we're able to get through with so little resistance to the patent office. And that saves legal fees, that gets you an enforceable patent faster, and you can start, getting licenses and stuff. And so there's a lot of benefits to it. And we can talk more about I can talk about that all day, but it's in my book, by the way, Patent Offense, which you mentioned. And I also, if your listeners would like to learn more about kind of what goes on behind a patent in a really unique way that no one else is talking about, I've got a webinar. It's free. Your listeners can go to my website at thompsonpatentlaw.com and scroll down to the how to start every patent webinar. It's absolutely free. My book is, you can also get to my book on Amazon through there as well at that website. So that's something your listeners can check out if they're really interested in this topic.
Absolutely. And they might be considering it and thinking for a long time, hey, this is something I want to do, but I haven't really taken the leap on it. It seems really huge.
Mm-hmm.
And I recall actually hearing in Shark Tank, sometimes when someone will come up with a really good product or an idea, the first thing that the Shark Tanks will say is, hey,
Right.
you have a patent on this puppy, because we don't want to put money in as an investor down on your product if it's not patented, and a whole bunch of competition can jump right in and grab that puppy.
Oh, yeah. And, now a patent isn't the solution for everything. I mean, a patent is a tool. It's like a hammer, but every idea isn't a nail, So, I mean, it's not the right tool for every idea. And that's why one of the unique things that the 7-step strategic patent assessment process that I talk about in my book and in the webinar as well is sorts out the ideas that you should get a patent from the ones that you shouldn't. And what I found that was really interesting is I worked with the biggest companies, especially at my old law firm, with Apple, Google, Intel, on and on and on and on. You can see the list on my website of really huge companies. And it doesn't matter if the idea comes from one of them or from a small medical company or electronics company or from a garage, startup inventor, an iPhone app or some, thingamajig invention. The thing that I found that's true for all of them, doesn't matter where the idea comes from. 30% of the time, we are able to tell them they shouldn't get a patent, which is really, really unique because we're actually telling people not to buy a patent from us because it's not going to do them any business good. And the reason when we put them through the 7-step process, we're looking for reasons for them not to file a patent. 30% of the time, doesn't matter where the idea comes from. That's our run rate as far as what we've experienced when we tell people your idea it fails for one of two reasons. It's not failing, it's just you shouldn't get a patent on it. It's the wrong tool. You should just save the money and just go to market, spend it on marketing, spend it on prototypes. Don't waste your money on patents. And it's for one of two reasons that come right out of our 7-step process. And that is, it's either not patentable or not patentable enough. It's not likely to get through the patent office. Or if we have a point of novelty that we think is patentable, if you can get a patent on that point of novelty, it fails for business reasons. One of 4 business reasons. And, things like it's too easy to design around, which is what you put your finger on. And your question is, what you can protect is too narrow, then your patent really is not going to slow people down. It's not going to be valuable. It's not going to be worth enough. And you're going to be spending money that you really don't need to spend on getting a patent.
Yeah. Wow, this is fascinating. And you often talk about a patent cycle. What exactly is that, and why is it important for businesses to understand what the patent cycle is?
Well, the patent life cycle is, the patent went from the day you file it to the day it expires is 20 years in the United States.
Whoa. Okay.
And so, you want to, there's another reason to get through the patent office faster because your patent your 20 years is running as soon as you file your patent. But you are patent pending the day you file your patent. So I look at it as there's 3 phases. There's before the patent office, there's during the patent office, and there's after the patent office. After the patent office, that's the real end goal. That's when you can monetize and fully monetize your patent. You can sell it, you can rent it, you can exclude others from importing, you can keep competitors off the market from selling your invention or infringing your invention. You can sue people to recover royalties and lost profits if they infringed. And that's the whole end game. And so we begin with that in mind. The point of novelty, again, is what's going to keep your patent, make it command respect. Because if you have a weak point of novelty, you may have squeaked through the patent office and they may have given you a patent. But if there's other what's called prior art out there, somebody's going to go and find that prior art the patent office didn't find, and then they're going to attack your patent. And a lot of times patents will get invalidated even though they've already been issued. So you want to have a really strong point of novelty because you want to have it stand up in litigation when it's going to be really tested. And if it can stand up in litigation, people will recognize it. People with kind of litigation backgrounds like I have, they'll see that that's a strong patent, and then they'll just pay the license. They'll just pay the licensing fee. Say, okay, let's negotiate a license. We're not going to sue you because we might not win. So, but if you have a weak patent, those get sued on all the time. So it's sort of like, the old defense adage, if you're so strong, nobody's going to attack you. If you build up your military, you never have to fight a war. It's kind of like if you have a really super strong patent, it's going to command respect. And that makes it easier to do licensing deals. And a lot of people, when they skip this point of novelty, they end up with a weak patent, almost guaranteed.
Yeah. And what I'm thinking, and the even more important reason why they have to give your office a call ASAP if they're thinking of doing a patent is and now this is what I read from the information you sent me, is that if they put through the documents and the patent goes through, it can't change for 20 years. You can't change anything to that document. It is as it stands, and that's your patent, period.
That's what, like baking a cake, Christina.
Yeah.
I mean, when you bake a cake, you mix up the batter and you put in some eggs and you mix up flour and sugar and whatever else. I don't know, butter. And then you put the batter and you put it in the oven, right? And once it's baking in the oven, you can't take it back out and add more eggs and flour and stuff. You can't do that. Same thing with patents. Once you file a patent application, whatever you put into that patent application, that's what you have to live with for 20 years. And what catches a lot of people when they try to go cheap, and they try to save a few dollars, or they try to do it themselves, they end up, once they're they're already in the oven, they're already in the patent office, and they realize that they left something out, or they didn't go deep enough on something because they didn't know exactly where the point of novelty was, and they kind of missed it. Then they can't add it in, and now actually, funny enough, they become prior art to themselves. It's too late in the game to add it in. You can't do anything about it, and the whole opportunity is lost. So that's why doing things right up front. I analogize it to a gambler and an investor. A gambler just says, hey, let's just, roll the dice and hope for the best. And that's how most people file patents. A lot of law firms, we've had to fix or try to fix a lot of things that were filed this way. That's how I discovered this when I saw what other firms were doing, and, that sort of gambling mentality. It's just, let's get it in and then let's hope for the best. And it's like a roulette. Our approach is, let's not always try to push patents. Let's just say, does it make sense? And approach it like an investor would, with due diligence. Investors make informed decisions before they make a decision to make an investment. And that's what I'm advocating for inventors and companies who are in your audience, is to not just always, go to a patent, even though that's what I do. To get the real result you're after is to do the due diligence, make an informed decision, and then not waste your resources. Because if you pull the trigger and file, like a gambler, you're likely to get to a point where none of them are getting through. You're wondering why. You're frustrated. You're spending $20,000, $30,000 on each one. They're taking 2, 3, 4 years, and you get nothing for it. And pretty soon you say, patent office doesn't work. The patents stink, but they don't. If you approach it like an investor rather than a gambler, your chances are going to be much higher. It's no guarantee, but your chances are much higher of getting a huge return.
Yeah, absolutely. And is there any part of the life cycle of a patent that's more important than another?
Well, if you think about before, during, and after, after is really what the results you want when you have a really litigation quality patent. But once it's patented, there's no changing you can do to it, really, essentially.
Yeah.
In the patent office, again, it's like that cake. Once it's in the oven, you can't add stuff to it. So the patent office, you're kind of locked in. Your feet are already in the cement at that point. It's too late. So the only leverage point you have in the patent process is before you file the patent application. And that's when you should do this due diligence. Like I said, I've been told by people who work with a lot of patent firms, nobody's doing this to this extent. And we're getting great results. Like I said, although we're turning away 30% of the people, we're getting patents through at incredible speed and with really good quality claims that can be licensed and sold for big money.
Yeah, but absolutely looking for in the end. Now, you told a really awesome story, a David and Goliath story about how you think, okay, if I get a patent, what if this big, huge company comes along and they just want to take me to court and steal my idea? And you told a wonderful story on how this little guy actually won in court over a huge company. Share with a little bit about it.
That's a concern a lot of people have, is they say they're a little jaded. They say, well, for us little people, we're just a small company. We're a startup. We have only, 50 employees, whatever. And we we would be competing with General Electric and we can't possibly, we don't have a legal budget for that. They're just going to bury us. And so it's not going to, why even try? Well, here's a little story real quickly. Michael Powell versus Home Depot. Would you say, Home Depot, that's a many billions of dollars revenue company. And Michael Powell was an employee of Home Depot. And in Home Depot, maybe you're familiar with, they have people at the back of the store that cut the wood with the saw for you. Well, what was happening in a lot of Home Depot stores is the employees were getting their thumbs cut off by those saws.
Wow.
So what Michael Powell did is he invented a thumb guard for those saws. Okay. And it was like a $1,300, he got a patent on it. You know, he did a patent on his own, and he's an employee of Home Depot. And so he had it manufactured and everything, and he was going to sell it to Home Depot. And his price was $1,300 approximately, if I remember that. I might not remember the exact numbers, but Home Depot bought it from China for $1,200. So they saved like $100. They were trying to save $100 per store instead of rewarding their employee. And so he sued them for patent infringement. He sued, basically his own employer for patent infringement. I'd say this is David and Goliath, right? Would you agree, Christina? I mean,
absolutely. I love it.
Right. They said his patent's invalid. They said they didn't infringe. They lost. Home Depot lost on every single issue on appeal. And so he won, it was around $20 million he won.
Wow.
So this proved the idea, the notion that we're too small. He was able to get like the second best law firm in the country to do the litigation for him.
Wow.
How did he do that? It's called contingency fee. If you have a really good idea and a real good business case, that's the winning formula. If you have a patent on a good litigation quality patent, there's a path there. It definitely exists. And so the ingredients are a litigation quality patent, and that protects a commercially valuable choke point, something people want. And those elements, the value is just very high.
Wow.
And even if you're small, you can be a billion-dollar company.
Yeah. Yeah, this is such an important story. I had heard years ago, and I don't know how true it is because I never really fact-checked it, but I had heard a woman who worked at DuPont made an invention, Kevlar, was it? Yeah, it was Kevlar, that then because she didn't get it patented, DuPont was able to actually then claim it and go forward with it. So if you're sitting on an idea right now, and that idea could be $1 billion idea, call Craige up today in his office because that idea, you don't want to be sitting on it and have somebody company come along or your employer and take it and run to town with it. You could be that David out there that defeats the Goliath. There's a lot of huge businesses out there, and there's plenty of room for small businesses to grow. But it's been so wonderful having you share this amazing information. What would you say, before we leave, is the top number one tip you want to leave everyone out here with regards to patents?
The number one tip, Christina, that I would say is the key to the patent kingdom. The key to getting through the patent office quickly, the key to a litigation quality patent that's going to command respect, which is the key to big licensing deals, the big exit strategy. If you control the balance sheet and if you're a shareholder, having a big blockbuster patent, the key to this is the point of novelty, and it has to come. You have to do it before you file your patent application. Otherwise, the horse is already out of the barn.
Wow, that is the most important thing. Well, I don't want us to leave without you letting everyone know where they can find out more about you, call up your law firm today and work with you, and get your wonderful book.
Well, thanks, Christina. My name's Craige Thompson. My company is Thompson Patent Law, and our website is thompsonpatentlaw.com. And when you go there, you can scroll down and get the free resource, the How to Start Every Patent webinar if you're a listener on this program. And also, there's a link to get our book off Amazon. And if you'd like to call us to just talk to me about your particular situation, my number is 512-649-1046. That's 512-649-1046.
Awesome. Well, I want to thank you again, Craige, for coming out here to share your very valuable wisdom today on Savvy Business Radio.
Thanks, Christina. I enjoyed it.